adjustment to be done. Yes.
So we were looking before lunch at the what we say is the core of the interpretive issue.
Yes.
The words "its publication." What was the intention of Parliament in putting those words in? What is it pointing to? What are those publications? And I accept and understand the point made by Lord Justice Singh that it's slightly circular, because you then have to come to the opening words, the proviso, and ask yourself what those are about and what Parliament's trying to achieve there. But for these purposes, up to this point, we say it's the publication of the statements that you're postulating as torts, that you're considering as possible torts. And I agree, of course, the outcome of the factual investigation into serious harm or no harm may mean that they're not torts, but that's not relevant for the purposes of the statutory construction argument. Of course, this may, thinking about it over lunchtime, and indeed thinking about it as this hearing approached, I mean, this may, in a small class of cases where there is an issue about significant change of circumstances looming further down the road, and a defendant may want to say, well, you know, an outcome at trial may be the sort of outcome we ended up with in this trial. And we're going to want to argue that those some scattered publications at the end don't cause serious harm. That may raise an issue relevant to whether you try and look at serious harm before the trial. You can see that. Although there's been a lot of judicial counselling against doing that anyway, but I mean, that would be a particular issue in that sort of case. But in a case where you've got a full trial, as here, you just reason out each stage, as this judge very clearly and very logically did, and it doesn't present a problem. But anyway, ultimately, all that stuff about when do you determine serious harm isn't relevant to the issue of statutory construction. Parliament will assume the courts will enable the proper investigation into the Section 1 issues, according to whatever the proper interpretation of Section 1 is. And so we say the problem with the appellant's interpretation is that harm here can mean something other than harm caused by tortious publications, namely, on the facts of this case, as illustrated, publications that occur when covered by the Section 4 defence. You can rely on causation of damage or harm from earlier non-tortious publications, and we say simply that's illogical and contrary to principle, and that our construction is logical and consistent with principle. And we would respectfully suggest, if Parliament was intending that outcome, and I'll come to some other reasons why their argument doesn't work, it surely would have said that expressly in the section. You know, I mean, I'm struggling for the word that my learned friend used to describe his interpretation. And I didn't quite get it before lunch, but I went back and had a look, and he very fairly said it's a crude, on their interpretation, it's a crude mechanism for interpreting serious harm. But surely if Parliament was intending to do that in a technical statute, using these technical words about the law, in the law of tort and the law of defamation in particular, it would have said so expressly. And we simply can't see anything in the wording of the section, explicit or implicitly suggesting Parliament intended to depart from the common law understanding of publication as the basis of a tort so dramatically. And of course there's nothing in Le Show to suggest that, but Le Show doesn't really deal with this point. I mean, I think we all have to accept that, those paragraphs.
What about section 15? Does that feed into your argument?
Yes, it does. I'm going to come to that in due course. But there are a couple of other important interpretive principles that we need to look at before then. And they come into play in this way. What you do generally in an interpretation argument is you test the competing interpretations and the possible outcomes. So you have ours, I've said what ours is, we know what theirs is, and I've made my basic criticism of that it just doesn't fit with a technical statute of this sort. The the two other well-known principles that come into play seem to us to be these. First of all, the principle that the court must look at consequences when assessing the competing considerations, competing constructions. The court must ask, does one have an adverse consequence? One that's likely to operate in an uncertain or unfair way. And the premise for that principle, which is well known, is that Parliament is unlikely to have intended an adverse outcome, an adverse operation like that. And as you've seen from our skeleton, we say there are obvious problems if you depart from the familiar tort defamation law concept of causation, which are not properly tackled by the appellant in his argument, advancing his interpretation. And you can come up with different hypothetical examples, but essentially, you know, it's the sort of example we're given in the skeleton, that you could be liberated to sue on and claim relief in respect of one stray reader, perhaps years after the initial publication that's covered by the defence. And it seems to us the appellant's only answer to this is, well, you know, the defendant could make a Jamil application. But it doesn't really answer the point of construction to say you could make a Jamil application. Because the point of construction, the principle, is to do with certainty and fairness.
Are you positing the situation in which you got judgment in claim number 1 and then not quite clear how that would work?
Well, that's the, I was going to come on and make that point. It's not at all clear how that would work, because how would you, it's the point we take in our skeleton. I mean, how would you know that you've got to make a Jamil you've got to make a Jamil application unless you get a reasoned outcome after a trial in a lengthy judgment like this? It would be entirely speculative. That's a very valid point. That's one of the problems with it. Why it's an uncertain, adverse, and unfair outcome. You would leave the defendant in that position thinking, well, what do I do about this possible result? And the Jamil application just really doesn't work. But anyway, we're only looking at a dry interpretive principle here, and my point is that even if you could do it and you could make it work, the submission that you make a Jamil application, which is a procedural application, it's a strikeout application on the basis the claim is an abusive process. That's neither here nor there for the purposes of this point of interpretation. My point is it puts the defendant in a really difficult position, and you get into that whole issue of, can I make a Jamil application and can I deal with it that way? And the idea that Parliament intended that as a possible outcome of this section on interpretation is unlikely, isn't it? I mean, it's unlikely. This is supposed to be a clear and certain provision that lets everybody know where they stand. In addition, as we say in the skeleton, could you even juridically, legally, properly make a Jamil application in that situation? Because the hypothesis is that the serious harm, the statutory test, has been crossed. That's the postulate, that you've crossed it, that you can pursue the claim. And it's difficult to see how a court could then undermine the statutory outcome by applying a common law line of authority, a Jamil line of authority, which was, as we all know, an earlier attempt by the courts before this statute to mitigate this sort of unfairness.
Well, driven by another statute, the Human Rights Act.
Driven by the Human Rights Act.
There would be a common law consequence of a statutory rule that qualifies a subsequent statutory rule.
Yes, exactly. And I mean, exactly. How could somebody in my position as a representing defendant stand up and say to a judge, here is this line of authority to mitigate a problem that was in play before Parliament tackled it and came up with Section 1.1, And I've lost under section 1.1, but you can still go back and I can have another bite at the cherry under that line of authority. The judge would say, well, you can't do that. That's Parliament can't have intended that as an outcome. So, I mean, the reality is, and I think this was a point my Lord Justice Warby tackled in the show at paragraph 50. Where does section 1.1 leave the Jamil line of authority in defamation cases? And the suggestion was, and it was dealt with by the Court of Appeal in its judgment in the show, but with some sympathy, I think, but it's effectively been subsumed into statutory test. Not in other cases. I mean, we've seen Jamil argued in privacy cases, in other cases where there are interferences with freedom of expression, breach of privacy cases. But in defamation cases, where Parliament's entered the fray in this way and defined the terms of what's actionable, it's very difficult to see how you could conceivably make a Jamil application. The other principle of interpretation we say must come into play here is the presumption. This is an extremely important point, not tackled at all by my learned friend. The presumption that the same word or words have the same meaning throughout the act. It's trite law. It's a presumption. And the weight of the presumption depends on the context. This principle that same words must have the same meaning attributed to them in different parts of the act. But of course, here in a technical statute of this sort, there's every reason to give the presumption great weight. It seems extremely unlikely that Parliament would have intended in a statute of this sort to give the same concept and the same words different meanings. But, and we've got section 4 and section 8 in the bundle. If we skip on from section 1 and the word publication, the concept of publication that we're looking at, which, again, putting it neutrally and broadly on the appellant's interpretation, is all the publications from the outset of the statement complained of, covered by the pleading, by the pleaded claim, by the particulars of claim, over that whole period, in whatever form they occur. Here we get in section 4 the word publication coming up again. And it occurs, it's a variant, publishing, in subsection 1, subsection 3, subsection 4. But as the outcome in this case on the section 4 defence shows, publication there has precisely the meaning that we're contending for. Precisely the meaning that we're contended for. It's precisely why we won on the publications before the defence lapsed and lost on the publications after the defence lapsed. Because that essential element of the defence, 4b, which is the defendant reasonably believing that publishing the statement complained of was in the public interest, was lost after the significant change of circumstances. So that publishing can mean different things under section 4 at different times. Precisely what we're saying in relation to section 1. And in passing, it's also terribly unfair that it would be terribly unfair to have two different meanings of publishing for those purposes. You can lose as a defendant on a broader meaning, on the traditional libel meaning of publication, each separate tort, and as my learned friend puts it, segment the chronology of the case. You can lose on a part of the case on that basis, but you give it a completely different meaning to help the claimant on subsection 1.1.
But Mr. Miller, how far does that submission go? Because Mr. Williams makes the point that if you take the strict common law position that each publication is an individual potential tort, then how does the concept of serious harm in section 1 work? Because on that analysis, you would have to ask whether each single publication causes serious harm, whereas everyone, I think, accepts that that's not how you do it. You look at the cumulative impact of, for example, 100,000 or 1 million tweets.
Well, there are more experienced defamation lawyers on the bench than I am, but my understanding is that there is a pragmatic approach has always been adopted in defamation, particularly in the old days of newspaper publication, where you could produce evidence of the circulation, not how many people actually read something, the actual publishees. Different problems arise in the digital era, but the courts have always been pragmatic in looking at, as we put it in the skeleton, groups of publications, provided there's a rational basis for identifying a group of publications. There's no reason on the facts of the case and on the issues of the case to treat different possible publications in that group differently. Then they're all in effect treated the same. But on on Berezovsky and that line of authority, they are all separate torts technically. They're aggregated for pragmatic reasons to do with liability and remedy issues. But that's the position.
I understand that's the position at common law, but I think the point that Mr. Williams makes is that if one is construing a statute, namely Section 1, subsection 1, this is the very task you're currently embarked upon.
Yes.
He says that its publication in that specific statutory context cannot mean the common law concept of each individual publication, because if it did, then you'd have to ask the question whether the one tweet has caused serious harm. And that, he says, that's a nonsensical way of applying subsection 1.
Why? On the outcome in this case, why would that be?
Well, that may be your answer then, but I'd certainly be assisted by your developing that answer.
Well, my answer to that is he's giving its publication the interpretation that he wants that suits him in this case. It's a piece of reverse reasoning, but he's not really articulating, according to the principles of interpretation, in the way we are, why it has to have that meaning. What we're saying is every principle of interpretation we can identify in the common law, well-established principles, points straightforwardly to it being technical defamation law meaning. And if that's the outcome, it's not an unfair outcome. It may be a simple answer to the case that there just isn't serious harm on one, but those are the facts of that case. It doesn't affect the interpretive argument, which has to be, as I said right at the beginning, based on the generality of libel cases and libel in the abstract, not specific examples. So that's our section 4 point, and it seems to us pretty well unanswerable. We're giving a different meaning to publication and publishing. Section 4, that is the common law, discrete tort interpretation, communication to each third party, to the one you're giving it in section 1. But it's the same word that appears in the header of section 4 to what you just read in section 1. It also seems to us, on their interpretation, that it must mean something different in section 8 as well, where you get publication in the header, single publication rule, applies if a person publishes a statement in 1A, it's in B as well, it's in 4, and it's in subsection 5. And as we know, what this is about is where publication, again in that sense of groups of publication, occur in sequence with a gap in time between them. So you get the concepts of first publication and subsequent publication temporally separated. And I think the example that's often given is the publication of a second edition of the book, where the same words that are complained of appeared in the first publication of the book more than a year before, but the claimant didn't sue on that publication of the book. They are different publications. They are what is being discussed in section 8 in that scenario is publication according to the common law understanding of what publication.
It doesn't necessarily have to be a gap in time other than a minimal one, does there? I mean,
no.
Suppose you've got 500,000 tweets or 500,000 retweets. It all happen within a very short space of time. the limitation period is always going to date from the first of those,
Yes,
not the second or the third,
Yes,
even if
exactly.
they're within seconds of one another.
yes. But my point is, what's the meaning of publication?
Yeah.
The meaning is clearly each individual publication, or pragmatically, each group of publications. So again, you're giving a different meaning to it in the interpretation of the appellant. And then there's the section 15 point. It's a slightly elusive wording. The meaning of publication in the Act is the meaning for the purposes of the law of defamation generally. But we would say that's a pretty strong pointer by Parliament in our favour towards our understanding of its technical meaning in the law of tort and defamation. And there's certainly nothing in there that suggests this sort of crude or broad meaning in section 1, or indeed that it has the word publication has different meanings in different sections in the Act. So our interpretation, we say, is all of a piece. It fits section 1, section 4, section 8 and section 15. And it fits with the concept of this, with this being a technical amending act in a very specific area of the law where publication has a very specific meaning that is peculiar to the tort. The appellant's argument of construction, by contrast to ours, as we understand it, alights on the opening words of section 1.1. A statement is not defamatory unless. And in the skeleton argument, the skeleton argument at paragraph 12, the appellant says, well, our interpretation rewrites section 1.1, or rather the judge's does, with the judge's interpretation, which we're defending at the end of paragraph 12 in the skeleton on page 16 in the bundle, as if it provided that a publication of a statement is not actionable unless that publication has caused serious harm. That suggestion, of course, involves a sleight of hand because he's not completing the rewrite to include the other words in section 1.1, and in particular the opening words. And the section tops and tails, begins and ends with words very specific to the law of defamation, which is about unlawful harm to reputation and concerning what is defamatory. He kind of impermissibly airbrushes them out of this rewrite of the sentence. Now, if he did include those words, his recast section would have to read something like, we start with his bit of it, a publication of a statement is not actionable unless that publication has caused serious harm. Then you would have to add in to the reputation of the claimant, and you'd have to then add in because this is what the section is saying, because in these circumstances it is not to be regarded as defamatory for the purposes of the law of defamation. That's what the opening words are doing. It's telling the reader what the outcome of that is, and it's an outcome, again, very specific to the law of defamation, namely that it's not to be regarded as defamatory for the purposes of the law of defamation. Of course, with respect, the wording of section 1.1 used by Parliament achieves this result rather more elegantly and concisely than my recasting of it there, but that's the import of it. And properly understood this way, the opening words are simply a concise tool or device, again drawing on how the law of defamation works, so that a published statement must be defamatory according to the law of defamation for a claim in respect of that publication to be actionable, to be brought. to achieve precisely the desired change in the law that Parliament wants, which is a particular actionability threshold, recasting the definition or adding to the definition of defamation in the law of defamation by adding a statutory layer to it. Saying it's not defamatory as a matter of law means there's no claim regarding that particular tortious publication. And then I suppose the last question, well, why use this tool? Why was Parliament drafting it in that way? Which perhaps to a non-defamation lawyer, without knowing the law in the way Parliament's presumed to, might seem a bit odd. But we come back to Thornton and TMG, don't we? Discussed in the show at paragraph 9. Unlike Jamil, which is a procedural mechanism developed by the courts for dealing with certain pleaded claims on the facts and certain types of cases, Thornton makes clear there is a substantive defamation law, common law threshold of seriousness for a statement to be defamatory and so actionable. And it's obvious, and it's confirmed in the explanatory notes, that these opening words are Parliament pointing at Thornton and making clear that the statutory law is adding to Thornton, and therefore obviously superseding it, replacing this concept of some sort of substantial tort, some substantial defamatory meaning, with a statutory requirement. That is serious harm. And it all makes perfect sense when you know the background. That's exactly why it was done that way. But you can't just do what the appellant is doing in this case, which is to alight on those opening words, say, well, they're the most important words in the section. To the contrary, we say they're not the outcome words, but they're not the most important words for the purposes of understanding its publication. They don't drive the meaning of its publication. What they do is they tell you what happens if you can't prove serious harm, and they do it by reference to this principle in this idea in the law of defamation. But the idea that the appellant floats, which is you can recast its publication on the basis of those words, is absurd. I mean, it's just existing in the ether, is it, up until that point? Statement is not defamatory. It has to be something to do with the publication that determines whether it's defamatory or not. And you get what that means from the remainder of the section. That's the way to read it. We also, as you've seen in the skeleton, suggest that the interpretation of the appellant as applied in this case would lead to an outcome which is not convention compliant. It's well established that an adverse finding in defamation proceedings and or remedies granted against the defendant in such proceedings are interferences with the right of free speech within the meaning of Article 10.1, and so have to be justified under Article 10.2. And in particular, as there's no issue about prescribed by law or pursuit of a legitimate aim, but necessary in a democratic society as pursuing a pressing social need and proportionate to the legitimate aim being pursued, which is the protection of reputation. We would say that making an adverse finding and granting relief in respect of speech, here the later publications of the words complained of, that is, finding them unlawful in domestic law terms because of earlier lawful speech as a necessary stepping stone to such a finding, and therefore interfering with free speech, could not be an Article 10 compliant outcome. It could not be necessary in a democratic society. And indeed, if the appellant's Article 8 rights to reputation were engaged on the facts of this case, which was not really an issue that was looked at trial, it's not a straightforward issue, particularly where somebody has been acting in the public domain to the extent he has. It was contentious at the trial, but to us, he was a quasi-politician, if you like, not elected, but the way he was campaigning in the referendum and the public profile he gave himself through the funding and the active role in the campaign made him equivalent to a politician. There would have been, had we addressed it, some serious issues about whether that statement complained of engages Article 8 rights. But even assuming they did, all that's required in Strasbourg is a fair balance between the rights. And we say, again, it wouldn't be convention compatible. It wouldn't be enough to say he's got Article 8 rights. That step in the reasoning is so offensive to the principles under Article 10 that it just wouldn't be sustainable. The Convention requires relevant and sufficient reasons for showing the necessity to get to that sort of outcome. And as we say, to find such reasons solely in earlier speech, which was lawful and had been proved lawful, could not conceivably be relevant and sufficient reasoning towards a necessity to interfere. And you only have to think about other Council of Europe states, perhaps more authoritarian than our own, and apply that principle to court challenges to freedom of speech there to see how worrying that line of reasoning is, that the lawful can render the speech unlawful. And as we say in the skeleton, the interpretive obligation in Section 3.1 of the HRA would support, I mean, it's a possible ours is a possible interpretation, and therefore we praise Section 3.1 in aid in support of our interpretation for that reason. Mr. Williams said, well, no one said, as I understand it, what he said was no one in the pre-Section 1 defamation cases, equivalent cases, where a defence falls away, ever said that the common law was not compliant. But the law was different then. Because you didn't need to rely on, you wouldn't have needed to rely on earlier lawful publications in domestic law to get to that outcome because of the presumption of harm. So that really doesn't go anywhere. It's a non sequitur. What you have to ask is, under this domestic law as it is now, is that impermissible reasoning? There are some points in the appellant's argument which are just plain wrong, which I just want to deal with briefly. In his skeleton at paragraph 14, he says that the judge's interpretation, if I've understood it properly, makes the section for defence a part of the statutory threshold created by section 1.1. Well, that's obviously wrong. They're two different things. Whether there is a published defamatory statement, which is something that claimant has to establish, is one thing. Whether there is a defence on the merits, which is something the defendant has to establish, is a different thing. They are juridically completely different concepts, and they will be dealt with in their logical order in a libel case, in a single judgment, as here, if there is one, to get to an overall judicial determination on liability in relation to particular publications, in the sense of communication to third parties. But they come into the reasoning at completely different stages in the reasoning. And you can see it in this judgment, which was clear and logical in the way that the learned judge dealt with it. You deal with the defamatory statement before the defence, and she simply held that in relation to the publications which are the subject of grounds 2 and 4 on this appeal, they weren't defamatory for section 1.1 reasons. Then very importantly, and Malone Friend lapsed into this in his oral submissions as well, the appellant says at paragraph 17 of the skeleton that the Act required him to demonstrate serious harm, I quote from his skeleton, as a precondition for bringing his claim, and he did so on their interpretation, as a precondition for bringing his claim. But again, there's no attempt to tie that submission to the wording of Section 1.1. This gets no assistance at all from Section 1.1. Section 1.1 does not say, it doesn't use the word claim, but it doesn't say, if I can rewrite his submission, proof of serious harm from some publications in all the publications you complain of in your pleaded claim means that the claim as pleaded is actionable. It doesn't say that. It's just reverse reasoning. There's nothing in the wording of the section to suggest it's about the totality of the pleaded claim, or what you choose to plead or what you don't choose to plead in terms of publications. And if Parliament had wanted to say this, again, we make the same point. If it had wanted to create a threshold requirement for a pleaded claim, for what's in the particulars of claim, it would have said so, wouldn't it? It's obvious. The appellant points at paragraph 18 in his skeleton to the fact that the successful defence prevented damages being awarded in respect of the publications that we successfully defended. As we say in our skeleton, that's rather underselling the consequence of our defence succeeding, which was rather more significant than that. What it meant was that those publications aren't tortious at all. So what is wrong with that? That's how our law of tort works. If it's not wrongdoing, it's not tortious, you don't get relief, you don't get a remedy. But in any event, that's just, in my learned friend's language, a sort of jury point, isn't it? It's not an argument, part of an argument of construction. It doesn't help on construction to point that out. It is a fact that he didn't get a remedy and can't get a remedy on the judge's finding. But it doesn't point in one way or the other on meaning, interpretation. The appellant argues that the judge's approach causes difficulties in practice for claimants, and we address that at paragraphs 43 and 44 in our skeleton. Though in its own terms, we don't accept that's the case. But our primary response would be, even if that's true, again, even if that's true, which it isn't, it wouldn't be relevant to the arguments of construction, applying the interpretive principles that we've addressed and focusing on the words its publication.
Well, I think it would be, because you've
such
pointed out, look at the consequences when you consider the competing construction.
Yes.
If the consequences were to create procedural mayhem.
Exactly. If it were adverse consequences of...
That would be an adverse
really
consequence
serious,
which you would not necessarily want to attribute to Parliament.
But defamation law, there are many aspects of defamation law that present difficulties for litigants, both claimants and defendants, difficulties to prove. It's not per se something that's so adverse or unusual that it should be taken into account on a construction argument. But the appellant ignores the fact that this issue has arisen because of a particular species of case, the one we know as the flood type, the show serious, significant change of circumstances type of case, which has become important in the digital age. So, flood, the article remained online. Show, the article remained online. Here, there's various forms of digital publication. As we say in the skeleton, a claimant in that situation can choose what they claim on, what publications they want to claim on. And faced with a Section 4 defence, a claimant could well take the view that there was, on the facts, a good Section 4 defence up to a certain point, and then it fell away. Similarly, with an honest comment defence that's based on some privileged statement.
So there was some discussion, wasn't there, at the trial of the falling away point? I mean, that was, if I remember correctly, maybe I'm misremembering, but I thought there was there were various candidates were identified as the point at which the on the claimant's case, the case.
Yes, very much. So.
On any view, under public interest was challenged.
Precisely. I mean, and it will arise in certain types of case that a claimant may want to have that fallback argument, and the claimant in this case chose not only to continue contesting the Section 4 defence in relation to the bulk of the publication on which he lost, but he chose also to run a series of, in fact, 5 sequential significant changes of events, which he put before the judge as possible changes of events. And she came up with the one on the 29th of April 2020, which was just over a year after the initial publication, on a basis which no one challenges in this case. It's a clear and sensible and rational conclusion. We didn't challenge it.
The question is, what is the consequence?
The question is what is the consequence of that? But he chose to plead his claim that way. He picked those stopping points. He can hardly say, it's not open to me as a claimant running that sort of claim, provided you understand the law properly, according to our version of the law, that I will need to address significant...
Was he right in saying, apologies for interrupting, was he right in saying that was Mr. Williams right to say that what wasn't addressed by either side, certainly as it were during the trial, was one consequence of the flood-type argument succeeding would be that the question of serious harm would have to be reassessed as from that point.
Well,
is that right? I mean, I think Mr. Williams said it wasn't part of your case, that was the position.
No, what he said was he took you to, or he referred you to our closing submissions at paragraph 135. Right at the end of our submission.
Remind me, is it from the supplemental bundle?
It's page 233 in the bundle. And you can perhaps just read that paragraph to yourself, but taking into account where it sits in the closing submission. So it's under F issue 5 damages.
Yes,
so we're here dealing with
I think that's what Mr. Williams said, which was that it was addressed as a damages issue.
Yes,
but not as a threshold.
Exactly. So you've got the assumption we're making at this point is we've lost in everything up until that point, including serious harm. What do we say about damages? This is not about serious harm.
But is he right in saying, which is the question I asked, that the judge's approach wasn't one that was advocated? It may not matter because we have to decide what is the right approach, whatever and however it came to be in the judge's judgment. But just
no, I think it wasn't explicitly addressed until the closing submissions, where it was addressed in all closing submissions.
Right.
And I think we would say that up until that point, the party, without addressing it at all in specific terms, the parties were at cross purposes about the meaning of Section 1. And that became apparent when the argument happened, and you can see it in the transcript if you look at it. But it wasn't explicitly addressed by either party. I think it is perfectly fair to say that the claimant's position was predicated on the sort of assumption we see as to meaning that he's putting forward in this case. He didn't have to prove serious harm in relation to those publications. But as you say, both for the judge and for this court, that's interesting but not directly important, because the judge has to apply the law, and if the evidence before the judge is that if the interpretation of the judge is our interpretation is correct, and there wasn't sufficient evidence to prove serious harm in relation to the publications covered by grounds 2 and 4, the judge has to decide that issue.
Yes, I follow that. But the one disadvantage from our perspective is that there isn't an express, that the parties don't deal with it in the evidence in the way that, depending on the outcome in this case, they might do in the future.
No, one of the difficulties with that, of course, where from our position, I'm not trying to cover myself, but one of the difficulties is we face 5 different possible significant
No,
changes.
I follow that it's not straightforward, but I'm just dealing with how it is and how it was at
Yes,
the trial.
no, it wasn't addressed in submissions in that way, but
Well, I suppose that by parity of reasoning, it might be that taking a pragmatic approach to this issue, evidentially, you might be looking for a significant change of circumstances that would prevent the court from drawing the normal adverse inference, or the normal inference from the scale of publication and the gravity of the publication.
yes.
Why would you say that if it was harmful in this section, it's not harmful in that section? You'd be looking for some reason to reach that conclusion.
Yes. But it would depend on what sections are, wouldn't it? It would depend on where the split falls.
Yes, of course, and you wouldn't be able to predict that with any confidence in advance, particularly if there are 5 or more candidates. But just as Mr. Banks was able to come up with 5 candidates, all plausible, arguable points, as far as one could tell, no one said otherwise, one could theoretically have a similar situation in relation to the issue of serious harm.
Well, I suppose it might be said that if we wanted to look for assistance on the issue, one might find it in relation to what is said about damages, as that would be something which would have to be addressed.
Well, yes, except in reality, what happens if you get to a stage in the argument like the one I took you to in our written argument, which is you've lost on everything or you've won on everything. The tendency of advocates for claimants is to say loads of damages. The tendency for advocates for defence is to say very few damages, very little, low damages. To the extent you can get away with that on the postulate of a finding of serious harm, but I don't know that positions taken by advocates in relation to that issue necessarily help greatly.
No, but I think everyone agreed, they seem to have agreed, that precision in these matters is not possible, at least in cases of this kind, where you're dealing with large-scale publication.
Yes.
And so, as you say, to a degree, one's got to take a broad brush approach to serious harm.
Yes. But so we were saying, on that hypothesis in that paragraph, if we lose on serious harm, well, very low damages anyway, because it's really just shaded serious harm. But our primary argument is it isn't serious. Well, I'm going to come to why in a moment. We say there's nothing impracticable about having to address different variants of your own case in this way. You've got to think carefully about your change of circumstances, events, dates, and think carefully about them in relation to both damages and serious harm, as well as whether they are a significant change of circumstances for the purposes of what you have to prove under Section 4. So those are our submissions on ground 1. It is a narrow point. I think both sides agreed, but it is a point of construction and has to be approached in that way, starting with the words and applying well-established principles of construction. And we say if you do that, rather than the sort of broad brush reverse reasoning to get to the result they want, which the appellant's side advocates, there really is only one answer to this that will make the law coherent and sensible. So I turn to grounds 2 and 4.
We're calling them grounds 2 and 3, I think.
Oh, I'm sorry. As pleaded 2 and 4, grounds 2 and 3.
Yes,
You'll forgive me if I keep calling it 4. I'll try not to. The test for intervention by this appellate court is as discussed. But just so that we're clear about our position, and you've seen it in the skeleton argument, the conclusions of no serious harm in relation to the tweet and the TED talk after the change of circumstances are evaluative conclusions by the judge. They're evaluative conclusions as to whether the statutory threshold was made out by the claimant on the evidence, based on all the evidence received. And I don't think there's any contention about that. The idea that the concept of seriousness, apart from anything else, is classically an evaluative concept. And that's akin to, as the authorities show, an exercise of discretion for the purposes of an appeal to this court. It's not the same as an exercise of discretion. It involves an evaluation of the evidence, but it's akin to that. What is required is indicated in Sprint Room, tab 7, in the authorities bundle, paragraphs 76 to 78. It's a familiar but very helpful distillation of the principles that this court will apply in deciding whether to uphold an attack on an evaluative conclusion. So I won't read it, the court's familiar with it, but essentially paragraph 76, it's made clear that the appellant has to establish a flaw, pretty serious flaw in the judicial reasoning, which undermines the cogency of the conclusion, such as a gap in logic, a lack of consistency, and a failure to take account at all of some material factor. And for what it's worth, I'm not quite sure what my learned friend's submission was on Civia, whether it really was a jury point about Mrs Justice Steyn, but I don't think a lack of consistency means a lack of consistency between two different judgments on the facts of two different cases. I think what's talked about there as a lack of consistency is a lack of internal consistency in the reasoning, applying one line of thought to the reasoning on the same point in different, or another one on the same point. 77, the court should be cautious in overturning these sort of evaluative conclusions for the reasons eloquently explained by Lord Hoffman in the Biogen case. Paragraph 78, the equally well-known observations of Lord Justice Lewison in Farge UK Limited, to the effect that where there's been a full trial and the trial judge has heard the sea of evidence and considered all the evidence, and there was a significant amount, particularly documentary evidence at this trial, to interfere with an evaluation reached at the end of a trial like that, the court should feel compelled to interfere. It should be that obvious that you have to interfere, that you should feel compelled to interfere, simply because, to distill it, you can't duplicate the role of the trial judge, and you can't consider all the evidence that she considered and processed in a very lengthy, detailed judgment.
The reasoning on the critical parts of this issue in Underground 2 and 3 is actually fairly brief. It's
fairly brief, but that's why we mentioned the English and Emery principle in our skeleton argument, and why English and Emery versus Emery is in the bundle. Even when an application was being made for permission to the judge, it was never argued that there was a lack of reasons as a distinct ground of appeal, nor has it ever been raised on this appeal that there should be that reasoning should revert to the judge for more explanation.
I think it's being said the approach was wrong in principle in a number of respects which have been identified, and there was no evidence to support the conclusions, putting it very roughly, to support the conclusions or the inferences which she drew.
Well,
it's another, well, you might say, another narrow point, and that's really what's being said.
Yes, I said I'll come to what I understand to be arguing and why it's wrong, but the reasoning is expressed shortly, but it's in a very long judgment, which the judge is clearly drawing on by shorthand other parts of it to reach those conclusions, particularly the reasoning in relation to serious harm generally. And you have to read it. You have to read it in any way. That's our submission. So ground 2 To come to Lord's point about ground 2, we say it is academic. You've seen this in the skeleton. We say it is an academic point on this appeal. For this simple reason. The judge found that the Section 4 defence covered the tweet until the change of circumstances. So that is over a year after, from June 2019, 29th of April 2020, that very long period. The tweet, the words of the tweet, were covered by the defence on the basis of Mr Justice Steyn's meaning. And of course you'll recall, I can't remember if I've got it in the bundle, but the reasoning of Mr Justice Steyn in relation to the tweet was familiar meaning reasoning, if I can put it that way, in a defamation case, applying the ordinary reasonable reader. And the approach he adopted was the ordinary reasonable reader, that hypothetical animal, reading the tweet, had to be taken to have followed the link to the TED Talk online, viewed the TED Talk to the point where that passage of 24 words is spoken, and the reasonable reader would take that meaning that he found out of it at that point. So there were the two publications together. There was the tweet and going through the tweet to the actual words to get to the meaning. No objection to that reasoning. It's familiar reasoning in relation to establishing meaning. The exercise in relation to Section 1.1, of course, is rather different. It's a question of fact about how many people ended up taking that meaning from the starting point of looking at the tweet, and that requires a factual investigation into the group and the readership and so on and so forth. Anyway, the judge found that the Section 4 defence covered the tweet until the change of circumstances. So the bulk of the publication was lawful. The appellant produced no evidence at all of publication of the tweet after this, specifically, or serious harm flowing from that. So it was always going to be a question of pure inference based on the evidence about the tweet and tweets and how they work. It's not accepted that there was any evidence, for example, that you could get the tweet on Google or anything like that. There was no evidence about that at all. All we had was the familiar principle that tweet drops down into oblivion fairly early on in its life and sits somewhere out of sight at that point, and indeed gets suppressed further and further down the chain as time goes by. So it would have required some pretty serious and direct evidence to suggest that there was any serious harm from that tweet existing 8 or 9 months after its initial publication. Still less people looking at it and going through...
Does that, in terms of threshold of serious harm, assume for the moment that it causes serious harm in a relatively short period of time? What would the impact of that conclusion be?
The relatively short period of time being?
From the date of from the first publication. You're saying it doesn't matter thereafter because it's covered by public interest defence.
Yes. On our interpretation of...
Well, the judge's finding.
And our interpretation of Section 1. So you can't rely on that serious harm. You've got to rely on whatever serious harm one might infer 8 or 9 months on, with the tweet having disappeared. And there simply wasn't any evidence of that. There was no basis for that inference to be drawn. Any harm, let alone any serious
Are you submitting, Mr. Bello, that ground 2 has no independent existence? Because it's assuming that ground 1 succeeds, and if ground 1 succeeds, then ground 2 is honest.
Yes. Yes, but if ground 1 fails,
then you say there's nothing separate to substantiate ground 2.
no, there's no evidence of or finding of serious harm, and it can't conceivably be said that I mean, it wasn't dealt with at all. But there's no evidence that this court or any other court could rely on to find serious harm in relation to that tweet at that point in time. And as we'll see when we come to the findings on both of these, it was the point in time that the judge was particularly concerned about. Very mindful of where we got to in the evidence and in the sequence of events by then. So on the tweet, it's ground 1 or nothing, we say, and there's no possibility of a remedy in relation to the tweet, injunction damages or anything like that, because there's no evidence of harm, and there's certainly no evidence of serious harm at that point. The appellant's position at trial, and ours, if I could just deal with that, his pleaded case is at B189, bundle 189. And it's amended particulars of claim, paragraph 15.2, Roman 3A. And it's very short.
Can you give the reference again? Supplemental bundle.
No, in the main bundle, in the amended particulars of claim, page 189. I apologise. It refers to the 311,000 followers, and then says that the first tweet was retweeted 8,915 times and appeared on the profile pages of those Twitter users and in the timelines of those who follow those retweeters. Didn't tackle the arithmetical issues that the learned friend has put forward, the hypotheses, as the basis of his appeal on this ground. Again, exactly the same if you look at his opening skeleton argument in the supplementary bundle at pages 70 and 71. Under the heading "The Tweet" at the bottom of page 70 and over on 71. Again, in much the same terms, he invited consideration by the judge of the retweeting, but again didn't attempt the hypothetical arithmetical exercise being undertaken here in this court of how many publishees there were as a result of the in this jurisdiction as a result of the 8,915 retweets. He just mentions it as a fact. That's what Twitter evidence shows. He didn't tackle the question of how many recipients of the retweet in this jurisdiction there were, or how many of them actually, as a result, this is the point I was making earlier on, actually viewed the TED Talk with its meaning found by Mr Justice Steyn, as opposed to just reading the tweet, which referred to Mr Banks as having lied. I said he lied.
That may be my fault, but I'm not following where this takes us. I mean, we're concerned with what the judge did and said and the reasons for her conclusion.
Yes.
Is the point of your submission that she can't be criticised for doing the best she could in the
Dealing with the argument that was, as it was put.
in the absence of any concrete information? But what sort of concrete information could one produce in this sort of situation?
Well,
Is it a matter of inference?
a matter of inference, but there wasn't even, the argument wasn't even, the point I'm making is the argument. The case is being re-argued here on scale of publication in a way that it simply wasn't below. And when one talks about, airily about, you know, each retweeter having 100, retweet publishee having 100 followers, and the assumption that all or a large proportion of them looked at the TED Talk as a result and got that meaning, which you have to look at the TED Talk to get. And let's say we're in the jurisdiction, and let's say we're people who weren't looking at it for a second time, who would already have had that meaning. Because
I think the argument was based on the judge's earlier discussion about what people did, the points earlier in her judgment about how how these matters were looked at. So I think this is the basis of the criticism of her subsequent paragraphs.
Not in relation to the tweet. I think there's separate consideration of the tweet. There's earlier consideration of serious harm generally in relation to the TED Talk. But the tweet is very particular, and the argument that's being advanced here is very particular. And there would be a number of obstacles to getting to this sort of arithmetical number that they're putting forward. It's simply unrealistic to suggest that everyone in this jurisdiction who receives the retweet in their timeline, which they get because of their connection on Twitter with the retweeter, would have gone on to watch the talk, which was something you had to do to get the meaning. And as I say, this could have been a retweet to someone who already viewed it, you know, when it originally came out. Some months had passed. So there's a risk of double counting. He certainly, I accept, did pick out some responsive tweets, and I'll say a word about those. But generally, in a moment, but I mean, generally, we say the responsive tweets, as per the judge's reasoning, give a pretty good flavour of why the judge concluded that the vast majority of Ms Cadwalladra's followers didn't think much of the appellant. So I'll just continue to give you the references. In his closing written submissions, the appellant said nothing at all specific about publication of the imputation via the tweet. That's supplementary bundle 151 to 154, paragraphs 20 to 28. His focus was on the TED Talk. Our closing submissions are at supplementary bundle page 200 to 204. Paragraphs 64 to 70. And there's a section on serious harm, and there's a long paragraph 66 with various subparagraphs. And an important part of our case was that the judge should not assess serious harm in blinkers any more than she should assess damages in blinkers, recognising the Burstein principle. And we dealt with that at paragraph 66. The most important paragraphs are B and C. A great deal of attention has been placed on D on page 202, but if you could just read B and C, you'll see how we put the case at the end of the trial. kind of have to take the whole judgment as read here. I can't pick through.
We have read the
Got the flavour
judgment.
of the whole judgment. So there's a big prehistory.
Yes, big judgment.
Big judgment. There's a big prehistory even before the first publication of the TED Talk. And we were inviting the judge to consider everything she knew about the background to this libel dispute. That is, everything she knew about the appellant's position in the lengthy public discussion that had preceded it in the press and in Parliament about his relationship with the Russians and the accounts that he'd given publicly of that relationship. To emphasise that especially that it was just unrealistic to suggest that these 24 words in a throwaway line in a 15-minute speech at TED, 99% about other matters, all of which had been argued about and debated, including by the two protagonists in this case, for months beforehand, could cause serious harm. That was the thrust of the submission. In oral closing, you get that exchange that's been alighted upon for the purposes of the appeal, which is in page 240 in the supplementary bundle. Internal page 19 in the transcript, so top right-hand corner. It's that passage at line 15 where Mr. McCormack deals with point D in our paragraph 66. But not much was said about the thrust of the argument, the Burstein point and assessing serious harm other than in blinkers. He really just responded to our points very shortly. And that was really the way the issues were packaged and ended up before the judge. That's what she was asked to consider. No arithmetical calculation about number of publishees or anything like that. And as I say, it was our case that there was an unreality suggesting serious harm on the tweeting. The judge directed herself with great care as to the law. You get this at paragraph 51 in the judgment, starting at page 73. I know my learned friend looked at it, but I just want to pick out some bits of it, if I may. Really, because these self-directions on the law point us towards how she was going to approach her evaluative determinations on serious harm, the sort of consideration she was taking into account. These are the things she considered clearly were important enough to give herself a direction on. Paragraph Romans 2, at the bottom of the page 73, it's important not to lose sight of the statutory qualifier, serious harm, the emphasis on the word serious. Paragraph Roman 4, she was very conscious of the burden on the claimant to demonstrate as a fact, a la show that publication had caused such harm. And at Roman 5, that there should have been an investigation as to the actual impact of the statement. She was well aware, see Romans 6, that harm depends on the reaction of others rather than the claimant's perception. And at 8, that inferences of fact could be drawn from the evidence as a whole, including the scale and circumstances, and we emphasise that, circumstances of the publication, the claimant's situation and the inherent probabilities. Then at 9 are Burstein, on which we made our submission, and at the end of 12, she was well aware of the percolation effect and the need to take that into account. And it's simply not fair or right, surely, to say she lost sight of those principles, as the appellant does, that she somehow lost sight of those principles when she gave her reasons in relation to serious harm. The whole point of setting them out there is to show that she's got them in mind, whichever way they play out on the facts. The evaluative conclusion regarding the tweet.
Sorry, just before you move on,
Yeah.
if I may, the proposition at Principle Roman 8, towards the bottom of the page and over to the top of the next page, even a seriously harmful allegation. I think Mr. Williams said that he reserves his position on that, whether that's correct as a matter of law. But can you just remind me, Mr. Miller, please, where the judge got the phrase, if those within the jurisdiction consist only of people whose opinion of the claimant is of no consequence to him? She cites my Lord's judgment in Ames. Is that an economy? Is that where it comes from?
Yes, I think so.
Right. So it's not something that the judge had just enunciated as her own proposition.
No, and I think she's using pretty well word for word
I see.
what's in those paragraphs. Sorry to double back. Principles of law, my lord. They're observations in earlier cases in relation to in the reasoning on serious.
Yes.
But one ought to be. It's fundamental to our position. You have to be very careful about elevating them.
I do understand that. It's just the way she introduced it
Yes,
at the beginning of paragraph 51.
She's showing she's got them, those observations, from previous judicial
But she called them relevant legal principles.
Yes. So at B85, accepting that the reasoning is brief, but there's no lack of reasons challenged, as I've said. The evaluative conclusion is surely at 94. That's the conclusion, and she has italicized and emphasized again serious in the third from last line. And it's clear, we would say respectfully, that her decision turned on the word serious in the statutory qualifier. So in her judgment, if harm was caused, it wasn't, for the reasons she's given, serious harm. The appellant's position here is to refer to these two matters as flaws in the judge's reasoning to the evaluative conclusion, which are supposedly sprint room flaws. First, as I say, he suggests she should have hypothesized, as he chooses to do in this appeal, about how many publishes of the tweet there were as a result of the retweets. And not only that, not only hypothesizing about it without any evidence, should have found that there were a huge number of publishes of the defamatory statement, the sting of the defamatory statement. That is, that Mr. Justice Steyn is meaning. Because
what was the? We have numbers, don't we, for the tweets? We do have some numbers.
For the tweet?
Yes.
Yes. Of her followers?
Yes.
Yes.
And for the retweets?
Yes. But by the time of the tweet, the TED Talk had been prominent and online for several months. From April through May into June, 3 months. And there's no evidence about who in this jurisdiction, who hadn't seen it before and is therefore counted already in the TED Talk figures, is looking at it at this point. Sure, you can draw an inference about that, but you've got to be really, really careful about doing that.
I was just wondering how you would work it out in other than an inferential way.
I'm not saying you wouldn't do it that way. There's any way you can do it in the absence of evidence, but you can't do it with precision. And what I'm trying to demonstrate is you can have argument both ways. So Learned Friend's argument here, which is the one that was not put forward below, optimizes the number. It's designed entirely to optimize the number of retweets. And within that group, the number of people who actually were publishees of the defamatory meaning. In the jurisdiction, hadn't looked at it before, hadn't taken the defamatory meaning already. Or you can put argument that minimizes it, that says, well, really all we have is the evidence, and that to draw inferences is a dangerous exercise. Certainly to draw inferences of big readership is a dangerous exercise. And that's the contest. But as an appeal, it would be difficult to think of an appeal point which is anything less than a complete re-argument of the case than the one we've got here. This is a complete re-argument of the case. It's not the case that was argued below. And you ought to be very cautious about finding that the judge erred in the sprint room sense in those circumstances. This court is not supposed to be a place to have a second bite at the cherry. The judges, what this court needs to focus on is that the judge's conclusion at 94, and you're either with us or against us on this, but it seems to us, given the effort the judge put into the judgment, and the details she put into it, and the way she directed herself as the principles, that you ought to recognise that her conclusion was a broad one, harm but no serious harm, and it was based on everything she'd heard and considered. And she was very careful, whilst recognising she could draw inferences, not to speculate, not to draw speculative inferences, without the evidence there to do that. And it's true that at 91 to 93, she distinguished, we would say quite logically, her finding of no serious harm in relation to the tweet from the finding of serious harm in relation to the TED Talk, and did so by pointing to the two crucial and obvious differences between the two, that is, the smaller publication and the fact that the tweet was published to a particular set of Twitter followers, rather than being published generally to people going to the TED Talk website and choosing to look at it. But the court would be wrong, we would respectfully suggest, to turn these paragraphs in the judgment into something that they're not. I.e.
Could I ask you to address what's in paragraph 98? This is the echo chamber point.
No, I was going to come to that on
sorry.
the TED Talk. I'm just trying to finish.
But it's a point which emerges in various parts of the judgment, including here. But
Yes. I mean, the short point is that it seems to us that it's covered by the broad general point that you have to assess look at what she's doing in the light of all the evidence she heard in the case about this TED Talk, the tweet. Who would look at it? Who would look at the TED Talk and take that meaning from it? Given that it's a global publication, and it's a global publication by Ms. Cadwalladr. So there's a whole set of considerations there to do with this publication that are quite unusual, which were at the core of the evidence in the trial, serious harm and damages. It's that echo chamber point has assumed a significance in this case that it really doesn't merit. It was a phrase that came up in those closing submissions. You can see it on the transcript. And she reproduced it in the judgment affirmatively for her own conclusions, because it was one that had been used by counsel. But she wasn't saying, I was going to come to this point later, there's nothing in the judgment to suggest she's saying it means what the appellant says it means. The appellant completely mischaracterizes it. The appellant says, well, this is all to do with people who didn't like his politics, people who didn't like his position on Brexit. This, in relation to the tweet and also in relation to who might be looking at the TED Talk later on, had become, I don't really want to use the phrase echo chamber, but had become an echo chamber by that point in time, given everything that had gone because of the polarised position taken by the two protagonists and the lengthy public debate and discussion about his finances, his relationship with the Russians, and what he'd said publicly about it. Nothing to do with politics, party politics, nothing to do with Brexit or not Brexit. It's to do with the two protagonists and all the evidence you read in the judgment about and indeed that was before the judge, about the sparring between them and about the coverage that Ms Cadwalladr promulgated about this story and exposing the story, and how the appellant had responded to it. And people took position. The evidence was clear. People took positions in relation to that. It was polarised, but it was in relation to that episode that predated the litigation.
So what do you say? You've heard from Mr. Williams what he says echo chamber means. What do you say the judge meant?
What she meant was in relation to both in these periods, the people who were looking, if you could isolate the people who were looking at the TED Talk through that route, through the tweet and going to the TED Talk, or through returning to or going to the TED Talk all that time later, a year later, were likely to be people who were doing that as supporters of Ms Cadwalladr.
That's the conclusion that I'm finding difficult to follow, because you can say they were followers on Twitter, but does that lead to the conclusion that they are supporters? Because Mr. Banks says that he himself was a follower, and for all I know, there may have been other people who are simply interested to know what this respected journalist has to say on a topic of public interest, without necessarily being supporters of her. But was there any evidence about any of this before the judge?
No, it's all inferential. I mean, and I don't think anybody is suggesting, least of all the judge, that all of them fall into that category. But
And
the
what
vast
about
majority of them did.
What about people who come to the TED Talk independently of Twitter?
Well, I was going to go on and say much the same in relation to those. It seems to us when you look at what she's saying in that section of the judgment, she's saying exactly the same thing. And what's critical is that she's talking about a particular point in time there. She's talking about that point in time where people are coming to it, not in the first months, but more than a year after it's gone out. Something has taken to them to look at it.
Why does that make a difference?
Well, for all kinds of reasons, because the argument has raged through the remaining period, including the litigation. And you see this in the judgment she refers to at different points. And there was argument about this in front of us. Just putting the litigation squarely...
I understand that, but why does it make a difference to the echo chamber argument? That these are people who are likely to, as it were, have a view.
Well, are people who would be her supporters rather than people coming to it afresh. Because there's no particular reason to come to it afresh at that point unless you're engaging with this debate and the issue about the litigation that she's raised continuously and has been raised in public debate and is the basis of the crowdfunding. But I mean, there are a whole host that you're talking about a group of people, a subset of people in this jurisdiction within that group at that point in time. That's the first point. You have to ask yourself, why more than a year after an event, does a certain number of people go back and look at it in that way?
Well, what is the way? That's my problem is I'm not quite sure what the echo is. There's a chamber, an echo is happening. What is an echo of? And
Well,
what characteristics does it give the person who's listening to it that mean that person's view of the claimant is not seriously affected in such a way as to result
broadly,
in serious
they've. I mean, I'm not entirely disclaiming the word echo chamber because the judge picked up on it and it came from Mr. McCormick.
Yeah, well, we're trying to analyse what the judge is saying, not
but if you read the judgment as a
criticising
whole,
counsel for the way they put the case.
if you read the judgment as a whole, I think it's pretty clear what it means. It means people who've engaged with that whole history of this issue, coverage of Mr. Banks.
And then, how do we then distinguish that line of thinking or reasoning from the prohibited line of reasoning that we know cannot be engaged in because Dingle says so and Lachaud says it all applies to Section 1. In other words, just because we know that these things have been said before,
But it's,
we can't infer
I agree.
that they resulted in a corresponding injury to his existing reputation. I'm finding a little difficulty in fitting this proposition into the existing framework.
Well, the mass of evidence and detail about what had gone on in that period makes it impossible to look at particular publications and things said in particular publications. I'm not sure it really is Dingle. I accept our argument about his general reputation failed, but that was broader than this specific point, which was about the Mr. Justice Steyn's meaning and how it would impact on whoever it was in that group who went back in this jurisdiction and looked at it in that period. I mean, you've got my point on the tweet. It was the earlier point. There's just no evidence that anybody did that or any serious harm resulted. The lady has correctly asked me to jump ahead and look at the TED talk where the numbers are slightly different but still quite indistinct. And it does seem to us that's what she was saying on the basis of the evidence as a whole in the case. That they were either people who'd been there before or who were going because they were supportive of her and wanted to look and see what the argument was about, because they'd been moved to do that by the whole debate that had gone on, which was essentially a political debate and a disagreement between the two protagonists. But it's certainly not politics and the party politics or the Brexit.
I understand, Mr. Miller, I understand all of that. But even just sticking for the moment to the tweet, and not the TED talk, just the tweet, and the followers of the respondent, must it necessarily be taken that followers on Twitter would already think that Mr. Banks has broken the law? And so this is simply confirming what they already think of him? Or is there some additional potential damage to his reputation, even in that class of people, that they now are being told that he's done something which is in breach of the law?
Well, certainly that was our case. The tenor of, you've got to read the whole judgment, and it's very lengthy. You have to go through everything that was said and published about this. But certainly it was our case that there were people who would think, as Ms. Cadwalladr did, that there were at the very least serious questions to be raised about it.
So that's the echo. It's not just that he's had a secret relationship with the Russian government, not just that he's told untruths, but that he's gone so far as to break the law.
Yes, that people were
So
thinking.
they would already think that.
Yeah. Well, that was an issue. There were questions to be asked about that in the circumstances.
That was the meaning that she intended to convey, but not
Yes.
the meaning that in fact came across.
Yes.
And you would say that for this purpose, there's not a very significant difference between the two.
No. And it was accepted by the judge that was what she intended to say.
Yes.
That was where
those are the facts as found, that she intended to convey one meaning, something more serious was in fact conveyed.
Yes.
But for the purposes of serious harm, we're talking about the meaning that was in fact conveyed, and your proposition is that there were people out there who thought as she did, i.e. they had formed a view that it was somewhat less serious than the meaning that she in fact conveyed.
Yes.
But your argument is that she was treating that as not a big difference for the purposes of serious harm.
Yes.
Not enough to get Mr. Banks over the threshold.
And it's accepted. She couldn't. Once the meaning had been determined at level 1, in those terms, it was accepted that we wouldn't seek to prove truth. But we did seek to prove Section 4, and we did prove Section 4. But it's very difficult for me to deal with this point concisely on appeal, because you've got to absorb the whole judgment. And this is a classic sprint room point. She had the flavour over 5 days of evidence, 6 days of evidence and argument about everything that had gone on in the meantime. She had volumes of bundles, including volumes of bundles of tweets and newspaper articles and discussion in Parliament and so on and so forth, that clearly left her with an understanding of who those people would be. The criticism seems to be she didn't articulate it, or she used shorthand, picked up on this phrase echo chamber. But whether that's a valid reason on Sprintler for overturning the end conclusion, we would respectfully submit is in serious doubt.
Since I'm the author of the proposition that's controversial here, can I ask about the Ames point, if I can put it that way? In other words, people whose opinion of the claimant was of no consequence to him. First question.
You can ask me about it.
Yeah.
If you help with the answer.
Well, I'm not going to do that. People have to make what they make of it. First question is the judge making two separate points in her paragraph 93, or is it the same point in your submission?
Well, I don't know to what extent she distinguished them, but she is making on the face of it, she's making a pair of points.
Yeah.
Certainly. We would say the more important one is probably right. They wouldn't have thought very much of the claimant by that time, for obvious reasons.
Well, then, so if it's a different point from not thinking very much of him, what do you submit the judge was saying when she made that statement in the last sentence, paragraph 93? Publishes people likely to be people whose opinion of the claimant was of no consequence to him.
Well, I think on the basis that, probably on the basis that Malone and friends put in their skeleton, which they think is of no consequence to him, and therefore it can't impact on him in any practical way in terms of damage to his reputation. I mean, I don't. You have our submission. We made it in the skeleton.
Yes.
The evidence showed that he regarded Ms Cadwalladr as a journalist with a degree of contempt, and there was evidence that suggested that he didn't regard her supporters much more highly than that. And the judge latched on that. It's part of this adversarial discourse that had gone on between them for many, many months, which was in strong terms, but part of a public debate. But it's a unique feature of this case. It is at the core of this case, and all the other cases that Malone Friends referring you to, they're not like this. You know, I mean, with respect, Monroe and Hopkins and the Riley cases didn't have this long prehistory of the protagonists sparring with each other publicly, or people taking.
The same point is made in paragraph 98 in relation to the TED talk, which is the likely to consist of people whose opinion of the claimant was of no consequence.
Yes, and it seems to us that it's born of the same body of evidence that the finding is made of in relation to the tweet. And in relation to both, she's very concerned to emphasise that she's talking about people at that point in time who are within the jurisdiction, who are accessing the TED talk in some way or other, whether it's through the tweet.
But the facts of Ames were very different, and my lord is not going to give you an interpretation of the case here and now, but it is the context in which the observation by my lord was made in Ames was very different to this context.
Yes. It doesn't
Perhaps
mean
we should have a look. Have we got Ames in the bundle?
But it doesn't mean the same observation can't be usefully applied in relation to this case on a different set.
Not saying that for a moment, but she does cite Ames when she, in the propositions of law you referred us to, as authority for that phrase, which then emerges again, both in relation to the TED talk and the tweet.
Yes, well, Ames is at tab 5.
Yes.
I think it's
It's page,
Subparagraph.
page 119 of the PDF, paragraph 92.8.
Yeah.
92 subparagraph 8. Well, the point made by Mr. Williams, which at least is consistent with what I said, is that consequence is about consequences.
Yes.
Is it consequential in the sense that it has capable of having an impact on their life?
Yes.
I suppose if Mr. Banks had gone on record and said, I don't give two hoots about what Carol Cadwalladr says about me, or rather what her followers or the readers of The Guardian may think of me on this topic, and then said, but I've suffered serious harm because of what she published, that might have been challenged on the basis you can't say that. Can't be heard to say that.
Yes.
That would be one way of putting it. But that would be a different way. It's another interpretation of what consequential might mean. It's of no consequence to him because he doesn't care, so it's not serious on that interpretation. It may be that what she meant was exactly the same as the first point in the same paragraph. Yes. It's not consequential because in their eyes, he was the kind of person that he was being that he was being depicted as by the tweet and the TED talk.
Yes, but it does seem to us the other part of it is the more important part. The observation they wouldn't have thought very much of the claimant by that time, which according to the Supreme Court in the show is something you can take into account. But I mean, I suppose rhetorically, aren't we dancing on the head of a pin here? This is a very big judgment with a very big finding based on everything that she's seen. And are we elevating this one sentence to a sort of error of law that, in an attempt to undermine the whole conclusion, is that appropriate? We would say not, and probably rather unfair to the judge. But anyway, so, my time is running out, but I think we've covered a lot of the points.
But there is, Mr. Villas, sorry, there is one specific point in paragraph 98 which it might be said is different from the tweet point, because when it comes to the TED talk after the 29th of April, the judge says that, like the defendant's followers on Twitter, it is likely to be people who are supportive of her defence of this claim, and within her own echo chamber.
Yes.
What evidence was there to found that?
It's all inferential. You can't cast a gaze upon the actual people because
Well,
you never know who they are.
Well, are we? Correct me if I'm wrong, but in the real world, as we know it to be, why should it be assumed that those who watch TED Talks are simply like the followers of someone on Twitter?
Well, I made the point. I mean, I think she's saying that the route at that point in time, the route back to the words complained of by either route is a product of what's gone on, the debate that's gone on, and the disagreement and the taking of sides. That's her explanation for it. The time point is very, very important. The point of time which we're looking at for both is very important because a lot of water had flowed under the bridge by then. But anyway, we would say you have to be very precise about who in each case, who the publishees were. You have to reach a conclusion based on evidence, and the onus of proof was on the claimant, and he clearly didn't, even on an inferential approach, in the light of all the evidence she'd heard, get the judge to the point where she felt he'd proved impact, the show type impact, on his reputation in the way required. Just one or two other points. We disagree the judge was making some general finding about Twitter, which is suggested in the claimant's, in the appellant's skeleton. And also it wasn't an impressionistic conclusion about the readership of a publication of the sort you see in the authorities he's cited, which is to do with meaning rather than the factual investigation that you get on serious harm. And in relation to the tweet, although I don't want to fall into the trap of re-arguing the case that I say my learned friend has fallen into, but there simply was no evidence that the tweet was coming up on a Google search. There was no evidence as to the percentage of her followers in the jurisdiction on Twitter, and disagreeable responses on her timeline could be, there's no evidence about this, but in the circumstances that we're looking at, could be an orchestrated campaign against her, or could be not even real people, could be bots.
I thought the judge had said at some point in her judgment that it was a reasonable inference that Twitter followers were within, or most of them would be within the jurisdiction.
Yes, but the percentage of them were in the jurisdiction. Yes,
Mostly said at 92.
Yes, 92. So that's the judge's inference.
yes, that's a Le Show imprecise conclusion. I can't question that, but it is imprecise. But on the TED Talk, you've got essentially our central point. There were two strands to the reasoning: a limited and shrinking audience in England and Wales, it's 97, and that inferential finding that those who viewed in this jurisdiction would be supportive of her defence in these proceedings, and wouldn't have thought very much of the applicant in this period, spring 2020 to the end of 2021. That is after everything that had gone on. As far as the first is concerned, you've got our point. The central public point on publication of the TED Talk was and always has been that it was a publication online by a US NGO of a talk in the US to a global and presumably primarily a US audience. In the complete absence of any evidence as to audience share in this jurisdiction. As far as we're aware, and this is a point of caution, Mr. Banks not only did he never adduce evidence as to proportion of audience share in this jurisdiction, as far as we know from the evidence, there's no suggestion that he ever even tried to get it from TED to see what proportion was viewed in this jurisdiction. You can't reach any particular judgments about the audience in this jurisdiction, the proportion of it, on evidence. In relation to the TED Talk before the defence fell away, she's saying, well, look, it's large enough for me to reach an inferential finding that a significant proportion of them are here. She's not prepared to do that after the defence fell away on a much smaller total number of viewings. I should say also there's no evidence as to whether what the TED figures included and whether those TED figures that were advanced in evidence included hits on TED through YouTube. These were things that were simply not dealt with in the trial. There was a series of boxes and propositions, but double counting was not something that, the risk of double counting wasn't something that came in the evidence. So to what extent can you hypothesize about it? Well, it seems to us that what she was doing was saying, as I've said, taking into account everything, you've got to be very careful about saying that the people who went back to it in that diminishing group after the defence disappeared, were published that would give rise to a serious harm complaint by Mr Banks. The appellant wants to argue, as we understand it, the talk was of general interest because of its title, Facebook's role in Brexit and the threat to democracy. And this supports the inference that non-supporters of Ms Cadwalladr were in this group. But it seems to us this misses the point that it was her talk, her personal views. TED Talks are very personal. They're attractive to viewers because people want to see that speaker. Seems to us that's in the judge's thinking. And the assumption, perhaps, on the other side is that she's not very well known globally or in the US in particular. And that's just not an assumption one can make. She's got a global profile. She was shortlisted for a Pulitzer. She's done work in America, a lot of work in America. She might say, but more of a profile outside of this country than in this country. You know, they make a great thing about her comment about wanting to bounce back into people in this country, something that's not mediated through the media in this country. But the whole point about it is the reason she was invited to give the TED Talk was because of her profile in America. It's an American global website. And we would say, although you can't precisely do numbers, a lot more could have been done by way of evidence by Mr Banks to address that, and the evidence simply wasn't there. So you've got our point. We couldn't conceive of a clearer case of a case being re-argued outside the evidence with hypotheses and jury points than the way this has been argued today. You've got to stay within the confines of the test for intervention, and we say that the appellant can't, on relation to either ground 3 or ground 2 or ground 3, show a fundamental flaw in the reasoning. On remission, I think, do you want to deal with that now, just briefly?
Well, do you want to hear?
Yes, of course.
Well, I think maybe.
I think probably first of all is in there.
And then you can respond to what he has to say, and then. There was one point which was made on the question of the what is I think described as an inherent unfairness in relation to the issue of the continuing publication of allegations which are said have not been defended as true, and where there is a limited defence of public interest, limited in time, I mean. But not after the 29th of April, but that it's said to be inherently unfair that the publications remain available to be viewed, in particular the TED Talk.
No, this was on the argument of construction.
No, this is an overall point that is put against you, is that the claimant is in a position where he's unable to obtain a remedy for the continuing publication of the TED Talk. That's the point that's made.
Oh, yes. Well, you have our answer to that, which is that it's not a tort.
It's not a tort because it's serious, not causing serious harm.
Exactly.
On the judge's finding.
On the judge's finding.
But you haven't identified, you said in your skeleton argument that that point doesn't bear on the interpretation issue because it's just not relevant. But you don't have another answer as to the general unfairness of what the claimant says is a false, demonstrably false allegation remaining on the record, even though there's no public interest in it being there according to the findings of the judge.
No, the answer is that if we're right on the interpretation, the judge's findings are right. Parliament's view is, and the evidence in this case suggests that there's not a tort there. That's the answer.
Or not this tort.
Not this tort, exactly. On these established legal principles. The law isn't there to determine unfairness. The law is there to decide cases according to the law, according to the correct interpretation of the law and the application of the evidence. So it's not, it's a jury point, it's a merits point, but it doesn't go anywhere. He has to establish a tort to get a remedy. If he establishes a tort, he gets a remedy.
And for the same reason, do you say, Mr. Miller, that there's no obligation on anyone to have some kind of rider put on the TED Talk? If someone watches it today, no rider needs to be added to say that there's this statement here which isn't true, and after the 29th of April 2020 there was no public interest defence either.
Well, I think the someone would be Ted, wouldn't it?
I'm sorry?
I think the someone would be Ted.
Yes, possibly, but you say there isn't an obligation on anyone, including Ted.
Well, I think it would have to be Ted because it's there.
Yeah, but that's the state of our law on your submission. Is that right?
Well, you've got to bear in mind that for reasons of choice, Mr. Banks sued my client in this country as an individual. He didn't sue Ted. He didn't sue Ted in this country, and he didn't sue Ted in the United States.
Right.
So he hasn't really got an argument, I'm afraid, if his complaint is against Ted for not amending the rules.
No, I was just asking a question that a reasonable member of the public might
Oh, yes.
ask. Not really a point in the appellant's favour or in your favour.
No, but what I'm saying is there were other options
Yes,
for
yes.
Mr. Banks in terms of litigation. He chose not to pursue them.
Yes.
Yes, just on that last point, we all know, or I suspect we all know, the difficulties in bringing defamation claims against American entities. But the point is, whether it's a good point or a bad point, the point is that it would be precisely the same situation if the video was up on Miss Cadwalladra's own website. On my learned friend's state of the law, there is nothing that could be done to compel her to qualify a statement which she now accepts could it be justified. And that a private apology has been made for. So my learned friend engaged in a little bit of misdirection there, saying, oh, well, Ted's American. His argument takes him to the same destination if Miss Cadwalladr herself is responsible for any sort of future publication of the talk, as in some ways, in fact, she is through her crowdfunding platforms, which do contain links to the talk, as I believe is common ground. Coming back to my reply properly before coming to consequences at the end, my learned friend began by saying there needs to be a laser-like focus on the words of the statute, with which of course we agree, but he then somewhat curiously fired the first beam of his laser at the second half of the statutory definition, with the focus on causation, with an argument, which I think was a new point, that causation in section 1 must mean tortious causation. And in our respectful submission, there is no sanction at all for that new point in the wording of the Act. And it confuses overall liability with the argument with which section 1 is actually addressed, which is whether a statement crosses, in the words originally used by Mr Justice Tugendhat in Thornton, but then adopted elsewhere, whether the statement crosses a threshold of seriousness. And indeed, as my learned friend was good enough to accept, in many ways his argument leads to circularity, because section 1 is saying what is required to establish one of the building blocks of the tort, but he then says, well, you have to answer the section 1 question with reference only to what damage was in fact tortiously caused. And it takes you into a sort of logical loop, and it brings in the availability of defences. But as we've said already, the availability of defences shouldn't be relevant to the section 1 exercise, because section 1 is devoted to asking what is defamatory. Now, the existence of a defence doesn't mean that a statement isn't defamatory. It simply means that it isn't actionable, or it isn't compensable, and that's a different question. So in our respectful submission, that new point with which my learned friend began was misplaced. We also say, and this will tie into the reply that we make on what I, with respect, would agree with my lady the President, is the key question of what does publication mean in section 1, so it's relevant to that as well. But we also say there's no basis for the way in which my learned friend approaches this, either limb of his argument on section 1, when you look at the limited exercise which Parliament was specifically embarking upon, which we say was localised to a fortification of the principles which had actually begun to be developed by the common law under the aegis of Article 10 with Thornton and Jamil. What Parliament was intending to do was simply to provide a boost to those principles, and it's an entirely localised development. And we say also that that's supported both by the wording of the statute and also by its explanatory notes. And I know I referred to them in my main submissions, but I do think it is perhaps just worth looking at them again. They are contained within the body of aims, which is tab 5, page 106 of the PDF. So it's not sidelined, but it's the indented section on page 106 of the PDF by marginal D.
Paragraph.
It's paragraph 49, which for my Lord Justice Singh is. Sorry, well, I can't tell you. I'll give you the page of the report.
I have it. It's all
You've
right.
got it? Splendid. I'm much obliged. So what the explanatory note says, this section, this is specifically in connection with section 1, builds on the consideration given by the courts in a series of cases. So the question of what is sufficient to establish that a statement is defamatory. And then he gives the recent example of Thornton was identified as authority for the existence, and there's the phrase, a threshold of seriousness in what is defamatory. There is also currently potential for trivial cases to be struck out on the basis they're an abusive process because so little is at stake. In the Jamil case, it was established that there needs to be a real and substantial tort. The section raises the bar for bringing a claim, so that only cases involving serious harm to the claimant's reputation can be brought. All of that, in my respectful submission, is completely consistent with the proposition that it is simply an initial and holistic valuation of whether serious harm has been suffered. And the metaphor of raising the bar, which the court will see, is not an advocate or even a judge-created term. You can see it's in the explanatory notes of the section itself. And what it focuses on is the bar to bringing a claim, so only cases involving serious harm can be brought. And the focus isn't on publications, it's on statements and cases. So although Section 1 is a significant interference with the law, it's a localised one. It is a boost to these principles the common law was already beginning to develop, but it takes none trivial up to seriousness, and it requires an actuality of harm rather than a tendency. And when my learned friend says, and he said it multiple times, this is a technical amending act, Parliament can be expected to have gone through matters consistently in a thoroughgoing manner. That is, with respect, the complete opposite of how Lord Sumption characterises this legislation in Le Show itself. Whereas, I say, he says it's piecemeal, and he argues that even within the Act, there's not a joining up between Section 1 dealing with the defamatory statement and Section 8 dealing with limitation. Coming then to the meaning of the word publication, it's stated by Section 15 to have, quote, in relation to a statement, the meaning it has in the law generally. But the meaning it has in the law generally in our submission is communication with a third party within the jurisdiction. That is the meaning of the term publication in the law of defamation. The Brunswick principle isn't a principle about the meaning of the term publication. It's a legal rule about when causes of action accrues. But in our submission, all Section 15 does is it imports the well-established principle that in this context, a publication is a communication with a third party. Of course, there are some old rules about whether that can include your spouse. We don't need to get into those. So in our submission, and I know it won't be improved by repetition of what I spent the morning saying, is that Section 1 is simply concerned with whether serious harm has been or is likely to be suffered as a threshold test, which we say necessarily requires a holistic assessment. And the Brunswick principle is simply foreign to the issue with which Section 1 is concerned. And when my learned friend says, well, publication is also used in other parts of the Act, but in Section 4 it's used simply to define the scope of the public interest defence and when it arises. And of course it may be said that Section 4 assumes the survival of the Brunswick principle, but that's hardly surprising in circumstances where the Act doesn't abrogate it. But as I have already sought to argue this morning, our interpretation of Section 1 entails no argument that Brunswick has been abrogated. our argument is simply that the purpose of Section 1 is completely alien from the circumstances in which the Brunswick principle arises, because Section 1 is simply a holistic assessment as to is this statement one which has caused or is likely to cause serious harm, analysed holistically, and if it does, it crosses the bar, and if it doesn't, as I've said before, you don't cross the bar, you never even get to the defences. Now, my learned friend then talked about the consequences, and he says the consequences of our submission is that a claimant gets a potential remedy for inconsequential harm. But my first answer to that is a crude so what. What on our analysis, what Section 1 has done is raise the initial bar. If you've got over that initial bar, then you are potentially entitled to a remedy for harm at a point which it is no longer serious. But it had to cross that threshold in the first place, so the Act has worked to weed out all those cases that don't cross that bar. But of course, even if you cross the bar, it is quite wrong to say that there is any sort of automatic entitlement to remedies for harm which is inconsequential. Of course, a judge can dismiss a case because unprotected harm is trivial. That doesn't require a defendant to make a Jamil application. A judge can simply say, on the facts as I have found them, and the near universal coverage of the statement by a statutory protection through a defence, there is simply nothing which falls to be compensated. It is trivial, no remedy. That is not something which requires a Jamil application prospectively. But in other cases where a remedy can be justified, in our submission it leaves a judge free to grant a remedy if it's made good. And we would, and I know I've made this point already, we would say this is a perfect illustration of the vice which may suffer if a claimant in Mr. Banks' situation, who has shown a defamatory statement was made, is nonetheless deprived of a remedy for it, because as we've seen, it is still out there. People are still watching the TED Talk, and then there's been the further eruption of tweets from Ms. Cadwalladr overnight that I've referred to, in which she again makes references to Mr. Banks' connections with Russia, specifically in the context of the Brexit debate. So this case shows very well, and frankly, Ms. Cadwalladr has fortified my case for me overnight as to why it is a naked injustice that Mr. Banks has no remedy in the position in which he finds himself, given that though she frankly makes no effort whatsoever to reveal it to her followers, Ms. Cadwalladr is not in fact maintaining her initial allegations could be justified as true, and in fact has promised not to reiterate them as part of the apology. But that's obviously not something we need to get into as to whether or not essentially she's broken the terms of her apology by her actions overnight. That may be an issue for the future. As for the points that I made about the impracticality of my learned friend's approach, well, the bench would have made its own, would have drawn its own conclusions, but certainly my submission would be that the debate with my learned friend Mr. Miller between bar and bench served only to confirm how it would tend to make trials far more complex and pose real problems for both sides. When one is addressing an issue which all previous guidance firstly accepts very often, it is an issue on which evidence will necessarily be exiguous, which accepts at the authority level of the Supreme Court, Lord Sumption speaking for a unanimous panel, necessarily involves has an impossibility of precision, but suddenly you are potentially needing to be very precise about dates, and potentially, as in this case, a range of dates, and a range of dates which only may coalesce into a clear target during a trial itself. Though I accept that ultimately points about practicality are never at the forefront of one's arsenal, there is, as in fairness my learned friend granted, there is, if something does lead to impractical outcomes, that may be at least a contextual indicator. It is not what Parliament or the parliamentary draftsperson had in mind. So far as my learned friend's points about Article 10 are concerned, I've mostly anticipated them this morning. But just to reiterate, in our respectful submission, his points are misconceived, because if the speech is protected, there is no liability. If it is not protected, there is no remedy unless it has caused harm. The only point that's significant is, on our analysis, you've got over the initial bar, and so there is no ongoing need to show serious harm. Even if it's called, but it still had to pass that raised bar in the first place. But if it does pass the bar, the defence has been lost and there is harm, then the harm that is sufficient to mandate a remedy, which is up to the judge, looking at all the circumstances, then Article 10 is not offended by the award of some vindicatory compensation or an injunction to forbid a future repetition. And in the only reason Ms Cadwalladr, on our analysis, is liable post-defence is because she is perpetuating a defamatory statement, which she didn't need to do if she had taken it down after she had ceased to have a reasonable belief in its publication. Then she would have no liability. But in fact, notwithstanding her apology, in fact, she has made no effort whatsoever to correct the record or take matters down. On the contrary, in the course of her crowdfunding, she has been drawing attention to it in a significant way.
I think Mr Miller says that she is not TED, and so the only person in law that could take down the TED Talk is the company that runs TED.
Well, certainly, for example, an award. Well, there are a number of points about that. The first is that all depends on what the terms are under which Ms Cadwalladr has licensed TED to broadcast her intellectual property, and she may or may not have rights to take TED down. I'm not aware there's been any disclosure of her contract with TED. I didn't appear below, so if I'm wrong about that, I apologise. But it can't just be taken as read. It depends on what I imagine would be some form of licensing agreement between Ms Cadwalladr and TED. But secondly, Ms Cadwalladr herself, in the jurisdiction, she can be prohibited from further disseminating, drawing attention to the TED Talk by ceasing to refer to it in tweets and in links on her crowdfunding page, for example. And insofar as through the agency in the non-legal sense of Ms Cadwalladr, Mr Banks has continued to suffer harm, then a vindicatory award of damages is something that he could point to in circumstances where she has not herself taken any effort, despite her so-called apology, to correct the record. So in our submission, it's impossible in this to see any offence caused to Article 10, particularly having in mind Mr Banks' own countervailing Article 8 rights. Coming to permission to appeal, the two permission to appeal matters, really, I think there's little that I could say in response to my learned friend that wouldn't be repeating myself, but I do have to just focus really on some particular lines of defence of the judge's approach which emerged today or were developed today. Now, obviously, my learned friend relies very heavily on those familiar and elegant dicta from Lord Justice Lewison about island hopping and seas of evidence and such like. And my learned friend constantly repeated the references to the sea of evidence in this case. But that with respect, is very skillfully done, but it's misdirection. There is a sea of evidence in this case, but not on these issues. I mean, it's the judgment on these issues, and it's really a striking contrast to the rest of the judgment, is extraordinarily compressed. It's not unfair to call it staccato. And far from referring to the evidence the judge has heard, the judge says in terms that she is proceeding on the basis that she's been invited to draw inferences from scale of publication, gravity, etc. So the judge's findings in this part of the case are explicitly not based upon the sea of evidence. I mean, in fact, we say there was evidence, and we criticised the judge in our main submissions for not referring to it. But even if we're wrong about that, and it's hopeless to say that this is a case where there is a subterranean sea of evidence on which the islands of her tweets and TED Talk serious harm judgments float. Now, since the judge was asked to proceed mostly but not exclusively on inference, what are the inferences in question? First, scale of publication. And the evidence about that, the number of TED Talk views, the number of followers on Twitter, the number of retweets and such like was essentially common ground. And we do maintain that that really makes the judge's conclusion impossible to understand. We say either she's left the relevant out of account and taken the irrelevant into account, for example, by focusing on relative versus absolute levels of publication as when you compare the TED and the tweet, or else she has come to a conclusion outside the range of reasonable decision-making, given the conjunction of the gravity of the single meaning, which no one suggests was other than grave, the scale of the publication, which for post defence TED talk and tweet alike we submit is on any view in 6 figures, and thirdly, the status, for want of a better term, of Miss Cadwalladr as the publisher herself. Because whatever has emerged about the actual responsibility of her journalism over the course of this litigation, her public perception is as a responsible journalist on a responsible and historic newspaper, viz. The Observer, using in the case of TED a platform which, as Mr. Miller himself has been at pains to stress, is a respected platform of international renown. Can I also just say this? My learned friend also, as part of this effort to identify an underpinning sea of evidence, he makes references to other pieces of evidence and other facts and such like. 2 points about that. Firstly, and it's the one from my Lord Justice Warby's intervention, it's very difficult to reconcile his reliance on those on either the Dingle principle or the judge's express rejection of my learned friend's arguments about general bad reputation. But second point, and no less important, it is wishful thinking in my submission on Mr. Miller's part. There's no reference to any of this in the judge's judgment, in the parts of the judge's judgment that deal with her reasons for finding neither the tweet nor the post-defence TED publication actionable. I mean, she doesn't. There's no suggestion that she's taken any of this into account. She doesn't mention it. There's no respondent's notice saying she should have mentioned it. And in those circumstances, on basic grounds of procedural fairness, and as clearly mandated by CPR 52, my learned friend is limited to saying the judge was right for the reasons she gave. And she doesn't give the reasons which my learned friend wishes that she had done. And that's also the right point. That's also a riposte, if I can respectfully say so, to my learned friend's emphasis about needing to view the TED talk in conjunction with the tweet. And maybe, well, that explains the judge finding that the tweet wasn't sufficiently damaging. The judge does not give that as a reason. There's no respondent's notice saying she should have given it as a reason. It's not even a point that was in my learned friend's skeleton. But we would note in any event, if one looks at the table in the judgment, paragraph 66, there is a huge leap in views in the months after the tweet. There have been, at the point of the tweet, there have been just over 2 million views. By just 3 weeks later, service of the particulars of claim, there have been another 300,000, and that's not counting YouTube, that's just TED. And then my learned friend makes points about responses to the tweets. Well, the judge doesn't mention them. We, in fact, say that she should have done. Mr. Banks does give clear evidence about the impact of those tweets on him and the fact that it was of consequence to him, to the extent that that's a relevant question. And if the bench has the opportunity during what I assume will be the reservation of judgment, I would respectfully invite it to look at paragraphs 93 and 95 of Mr. Banks' statement, where he does deal with that. But as I said already, the most vivid illustrator of this being of consequence is he has brought this claim. Now, of course, the riposte to that originally was, well, he hasn't brought this claim in good faith. It's a slap, it's oppressive, it's abusive. He's singling out Miss Cadwalladr, he's a bully. But all of that was rejected by the judge. Once that's rejected by the judge, we do ask rhetorically, how can you possibly say that all this is of no consequence to Mr. Banks when he's put his reputation and hundreds of thousands of pounds on the line by exposing himself to what we all know is the often extremely risky crucible of libel litigation. So in our respectful submission, even if the judge has understood what my lord said in Ames correctly, there simply is no basis for what she's concluded, and in fact she ignores evidence that Mr. Banks actually gave. So far as the echo chamber is concerned, my learned friend, in our respectful submission, gives no convincing justification either for there being an echo chamber at all, or that it's an echo chamber so dogmatic that all its members specifically thought badly in respect of Mr. Banks, in respect not just generally, but in respect of the single meaning. and there's just no evidence at all that could possibly underpin that. And we do say, and I can understand why forensically my learned friend attempted to suggest this was some sort of something the judge had picked up from Mr McCormick that wasn't really consequential. But in our respectful submission, it's clearly at the heart of her reasoning on both the tweet and the post-defence publication of the TED Talk. And she says that in terms, two crucial reasons, she says, for the tweet at least, and this is one of those two crucial reasons. And when she comes to the post-defence TED Talk, she specifically adopts what she has already said about the echo chamber, and she applies it to TED, notwithstanding, as I have said, the defendant's own evidence was the very thing that drew her to TED, was it was outside her bubble. And insofar as my learned friend says, oh, well, TED's all American, I mean, she also says that she wanted to reflect matters back into the UK. And my learned friend, again, he doesn't address, in this attempt to throw up, oh, well, the judge probably relied upon a lack of domestic publication. The judge herself has already found that TED publication before, in the early stages, is the equivalent to a mass circulation newspaper. And even if one takes the point that the subsequent publication is only at about 10% of that level, 10% of a mass circulation newspaper is still a mass publication, and not that far from the sort of readership it's certainly greater than the readership of any regional newspaper, and not very far from readership of some of the less popular national newspapers. So far as, lastly, the questions about from my Lord Justice Singh about whether or not Ground 2 is academic if Ground 1 fails. In our respectful submission, it isn't academic because of the points that I've made about Mr Banks's entitlement to an injunction. And he's certainly entitled to an injunction on the tweet, and also vindication. Whether that leads to a modest or a generous award of damages obviously would be a matter to be argued. But given the risk of vindication and the stark failure of Miss Cadwalladr to do anything to correct the record, in our submission, if it is not academic also on the point of there being a well-arguable case for at least some compensatory award of damages by way of vindication.
So, Mr Williams, can Ground 2 succeed if Ground 1 fails?
Yes, if Ground 1 fails, so that the whole of the tweet, on the assumption the whole of the tweet is subject to the defence, which of course isn't an issue the judge examined. Yes, it can still succeed because. So let me just order my thoughts on this. It's been a long day.
I understand.
Yeah, exactly. That's what I thought. Sorry, the reason I was momentarily confused because I thought I'd already answered it, but I was probably just speaking too quickly, as is my wont. We say it is not academic because of the entitlement to an injunction and at least some vindicatory award.
No, I understand that. But is that all premised on an assumption that Ground 1 has succeeded?
No. Because if Ground 1 succeeds, then. Clearly, Ground 2 has to be considered, I would submit, whether or not Ground 1 succeeds.
Right.
That's my answer. So those are my responsive submissions. So far as remedy is concerned, I'm very grateful to my lady for pointing out what is said in the N161, which I have to confess I had not picked up upon. My invitation to this court, if the appeal is allowed, is clearly not to remit matters to be redetermined. It is for this court to substitute a finding that serious harm has been demonstrated. There has been an event of defamation, and essentially enter judgment on liability with damages to be assessed. And whether that's damages assessed by this court potentially on written submissions or else by a remission to a judge of the High Court would really be a case management decision for this court. I appreciate that in modern times it's become quite unusual for the Court of Appeal to get heavily involved in consequential issues. And so we'd really be in the bench's hands on that. But certainly from our perspective, we would be content for damages to be considered by this court, but clearly that couldn't be done on the materials which are presently available because neither of us address it in our skeletons, for example.
Thank you very much, Mr Williams. Yes.
Can I just clarify what the hypothesis is here? Obviously, it's the ground one fails.
Well, there are a number of potential.
Yes.
I mean, we need a sort of route to verdict here. I think if on the claimant's or the appellant's case, they're asking for a remedy if they're successful on one or more of the grounds of appeal,
Yes.
or appeal ground 1 and application for permission grounds 2 and 3.
Route to verdict on ground 1, if on ground 2, if this is the point Lord Justice Singh was debating with my learned friend. This is the easy bit from our point of view. If ground 1 we succeed, there is nothing left in ground 2, because in relation to the tweet, some serious harm would have to be proved after the defence, and there's no evidence of that. The tweet had disappeared, so there's nothing to remit on. It would be a pointless remission. To try and establish, as I understand it, try and establish some serious harm, have another bite at the cherry. And I think that's what's being envisaged, because he would still have to establish serious harm on that as a sort of freestanding issue, serious harm in respect of the tweet. On that hypothesis, after the defence falls, no evidence, no basis for remitting that. Ground 1 succeeds, and in relation to ground 3, we appreciate the current reluctance of the Court of Appeal to try and resolve things finally, but my client does not want another hearing. Does not want to go back to the first instance and have another hearing. She wants finality, and she wants it in this court if she can.
And one possibility, obviously we haven't reached any conclusions at all at the moment about any of it, is to come back to this issue if it arises once we have determined the issues that are full square before us at the moment, which is an appeal on ground 1, applications for permission, and determination if we give permission on grounds 2 and 3.
Well, I have recently had a very generous indication along those lines from this court, and it is very helpful to counsel when we're asked to address remission on various floating and variable hypotheses. If the court can allocate a bit of time to do that in light of the judgment, because it does make things a little more concrete when you look at that issue.
Yes, sorry, I wasn't sure if you were looking at me to speak, my lady. I was just going to say, certainly if the bench is willing essentially to defer that issue until we see the draft judgment, for example, it may be with sight of the draft judgment, if the issue arises at all, there can be some consensus with us about how best to proceed, subject of course always to the bench's approval. So if you were willing to allow the parties time for consideration with the draft judgment, we would respectfully support that.
Yes, I think we think that's sensible all round for many reasons. I think if you've concluded your submissions,
Yes.
then Mr. Miller, anything else you wish to say? On the point of I think we've reached the conclusion now of the argument.
Yes.
Right, thank you very much. Well, thank you very much to you and to all those who worked so hard behind you. As we know, cases like this require a great deal of preparation, and we're grateful to counsel for their submissions and for everybody, the work that they've put in to preparing this case. And we will, as you've anticipated, not give our decision or our reasons today, but we will reserve our judgment or judgments, and counsel will have an opportunity, as we have just indicated, following the circulation of the judgment in draft, to make further submissions. If that does arise, then we will give directions as to how that shall take place, but we won't anticipate what those would be now. because we haven't reached that point. The draft, obviously, the circulation of that is for the correction of any obvious errors and omissions and typos and so on, but not for re-argument, as I know counsel will understand. Unless there's anything further, we'll rise and thank you very much.
Thank you, my lady.